Good afternoon. I'm Dr. Lisa Bryant, and I am one of the risk management advocates for the Trust. We are delighted that you are able to join us today for our 26th Risk Management Roundtable. As a Trust policyholder, most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of the many benefits our policyholders receive through the Trust. I'm one of the 8 advocates, and I'm excited to be joined by 2 of my fellow colleagues and other advocates, Drs. Dan Taub and Eric Harris. Now we will get started. So welcome again, Drs. Harris and Taub. Really lovely to be with both of you. And Dan, I'm going to start with you. We're going to dive right in to initial 4 questions, and then we'll start taking the live. So the first one, Dan, as you know, right, we get many questions on interjurisdictional practice, and that continues to be something we get a lot of calls on. So can you comment on, is interjurisdictional practice really an issue at this time post-COVID?
Yeah. Well, I think as all of us have experienced, Lisa, it most certainly is, right? During the height of COVID, we received thousands of calls about interjurisdictional practice. And although they've modulated somewhat since the end of the public health emergency in May of 2023, I don't think it's an overstatement to say that we have received perhaps 15 or 20% of the calls we get weekly, second only to what Eric's going to talk about with subpoenas, have been about interjurisdictional practice. So it's still quite a hot topic, and for good reason. The calls that we get range from questions about, is it legal to practice, for example, into another state where you're not licensed? What if I am a SIPAC member and I'm not in my own state? Can I practice into another jurisdiction out of the country, right? Practicing abroad. And there are many questions that we get around the standards that have been put in place regarding SIPAC and the SIPAC Commission's regulations and how they affect practice for those folks who are members of SIPAC and have APITs and e-passports as well as the TAPs. Perhaps the most common question has to do, Lisa, with licensing restrictions, and what's important also in the questions we get too are for those clinicians working under SIPAC. There are often questions about what distant or receiving state laws are regarding a range of practice issues. That's also become much more common. So it's been a very steady and full stream of questions, because the situation, although certainly better with SIPAC, is still complicated.
I agree. It's pretty complex at this point. Eric, anything you want to add?
No.
Okay. Well, I'll just add the additional piece, Dan, I think, is in addition to everything you've mentioned, but also now practitioners are traveling too, right? And sometimes that adds another layer to thinking about some of these things. Yeah, we are seeing many questions.
And there is still some question if at some point Medicare or the government will require you to be able to see clients once every 6 months or once every 3 months. And every year now, the feds are making the new decision about what the rules are going to be about interjurisdictional telehealth practice.
Right. No, I'm glad you mentioned that, Eric, because I think that's part of what makes it complex, is that a lot still is changing. It's not yet 100% consistent. And then, of course, every state has different rules. So, yeah. Okay. Well, we're going to come back to that in just a few minutes. But before we do that, Eric, I want to send a question about subpoenas to you, because as Dan mentioned, that's the other thing that we get many calls on. So, and I'm going to give you this and it's sort of in a vignette. So let's say that a clinician receives a document purporting to be a subpoena from an attorney who states that they're involved in a lawsuit with a client that the clinician treated 6 years ago. The clinician has no information about the lawsuit, isn't even sure how to reach the client because their phone number no longer works. What should the clinician do?
Well, there's a standard answer to that, which is basically, I can't say whether or not I provided any professional services to this individual, but if I had any information about those services, would be privileged under the state law and couldn't be provided without either an authorization from the individual or a court order. However, I want to say a little bit about what subpoenas are and the different kinds of subpoenas and what you might do if you really did want to try and reach the client in order to find out what was going on and have more information about what you might want to do in that situation. So there are basically, we do, ever since I started in this program, which was 30 years ago, the most common question, without doubt, no matter what changes otherwise, is help, I've got a subpoena. And so, but there's still a lot of misinformation that people get confused about. So there are three types of subpoenas, basically. One is a subpoena directly asking for your records, otherwise known as a subpoena ducus tecum. Ducus tecum means you and the information. The second type of information is one that asks you to attend a deposition. And oftentimes, a deposition subpoena and a subpoena ducus tecum are combined with the option basically to say, if you turn over the records, you don't have to come to this deposition. And the third type of subpoena is a subpoena that calls for your personal appearance at the court in order to give evidence. And each of these are, people often ask questions about, well, I got a subpoena, but it isn't issued by a judge. Does that mean I don't have to pay attention to it? And the fact of the matter is that all subpoenas are issued by lawyers as officers of the court. So a subpoena is a kind of a court order, but it's not issued by a judge, but it can't be ignored. However, it isn't a kind of court order that can overturn the privilege in a particular jurisdiction. Now, there are some states that have different rules about subpoenas, and we can't go into all of them. But I will say that in Virginia, for example, when you get a subpoena, you can claim the privilege, but you have to forward the records that have been requested to the court and to the clerk of the court in which the case is in, and they make the decision then about whether to release the records to the lawyers or not. So in some ways, you're taken out of the middle of that situation. In Illinois, you can't have a subpoena issued for mental health records without a judicial permission specifically. So you have to be somewhat aware of your jurisdictional rules. Finally, I would say one of the things we can't advise you about is the very specific rules about what constitutes a legitimate subpoena. Every state has a lot of rules about how subpoenas have to be issued, how much notice they have to provide, what kind of service, do they have to be delivered in person? Can they be delivered through the mail? And our basic position is when you get a subpoena, you probably should assume that it's legitimate. But if you really are wanting to somehow not be involved in it, you would have to actually go to a local lawyer who then could probably file a motion to quash the subpoena if there was some reason to do that.
Great. Thanks. You fit in a lot of very good information there, Eric. Dan, anything you want to add to that?
You know, I just want to highlight something that Eric said that dates back quite a while for me as well, and that is that you can't ignore subpoenas. I had a supervisor many years ago, Eric Liesel, in the Mesozoic period, and the supervisor said, "Oh, you can just throw those away." Well, no, because actually a subpoena gives the court jurisdiction over you, meaning that they can fine and compel you. It rarely ever happens, but they could even put you in jail overnight if you don't comply. So you can't ignore it. But ignoring is, while it's not an option, responding is what I think, Eric, you were really talking about, which is you will most of the time respond by asserting privilege and not giving the records unless you have an authorization or a court order.
Mm-hmm. Yeah, thank you for adding that. And I too want to circle back just to clarify, and Eric, you did say this, but I think it's really important to remember that a lot of this is also going to be state specific. And so we're giving some general advice, but especially in subpoenas and maybe some of the other things we're going to talk about today, where there's a lot of state specifics. Consultation is one of the best things you can do, right? Having a low threshold for consulting and consulting often on some of these things is going to be really important. So.
One other thing I'd just like to add about, which is in this particular case, the therapists can't get in touch with the client. Many therapists would want to get in touch with the client before they actually take any position with regard to the subpoena to see what the client wanted. And one of the tricks that you can sometimes use is a subpoena will always have both lawyers on it.
Mhm.
And you can, even if you don't know how to reach your patient, your former patient, you can talk to the lawyer without revealing any clinical information. And often they will put you in touch with the client so you can get more information and more cooperation around what should be done with the subpoena.
Mhm. And understanding, as you say, what the client wants, and that does, do they want the records released or not? So yeah, great. Great. Okay, so Dan, I want to come back to you. We started on interjurisdictional practice, and I want to sort of pick back up there. And maybe you could, because a lot of the questions we get are, can I do it across jurisdictions? Can I not? Can I do it in the States? Can I do it, overseas? And so maybe you can just talk a little bit about the steps or things that a clinician should consider when making that determination on a case-by-case basis.
Sure, sure. Well, I think there are probably about four core considerations, Liesl. The first of which is the client suitable? I had an interesting interaction just this week with someone asking, is that really important since so many people are doing 100% of their practices remotely? And I think as risk managers, we'd all agree it's really important to look at how suitable is this client, especially if we're going to be doing longer term remote care. For the moment, I'll assume it's legal in the other jurisdiction, but that doesn't mean it's wise. Okay, so with more risky clients, more challenging clients, even though we don't have, base rates, our assumption is that if you have more fragile eating disorder clients or a person who's, for example, still using substances in a significant way or has significant suicidal ideation or even attempts, it can add layers of risk for clinicians over long distances. So the crucial initial step is telehealth appropriate for this person? And I would add to that too, in this first category, documenting your reasoning for that, just very briefly. Is it appropriate? Or is there some kind of rule out that you have? The second element is safety. And that has to do with even when you're working with stable client, you're a SIPAC member in Texas and you have a client who's in Illinois and good, stable relationship. All of us know we may be psychologists, but we're not psychics and things go wrong. So planning for how you're going to get in touch with emergency services quickly and directly in the other jurisdiction is a crucial component of the work that one is doing. If you call 911 in Dallas and your client is in Chicago, it's very likely that 911 in Dallas is going to say, why are you calling us? And even if they offer, as some jurisdictions will, to forward the 911 call, it can take literally hours. So one has to be very careful about safety. Third aspect is the financial component. And that is, purely private pay, not an issue. But Eric, as you were just talking about, will we be able to, next year, will we be able to continue to see Medicare patients, clients without seeing them in person? And if that person happens to be in Florida and you are in Arizona, that can be difficult. But if you have insurance, commercial insurance, there's lots of variability in the commercial insurance market about whether they will pay for services that are outside of the state where they have determined, for example, the person resides. Sometimes, as I've heard from some clinicians, when the clinician is no longer in that state, it can also cause some ripples around financial issues. And then the last core element, and Lisa, we were chatting about this the other day, is the culture and the law in the other jurisdiction. Though not as common as it used to be, there are a few nations remaining where if one makes a threat or an attempt at suicide, it is a crime. So if the only service for crises is to call law enforcement, the person will be jailed. Okay. States have many differences around things, for example, like involuntary treatment processes. So one has to know about the particular culture into which you are practicing, both within the US and outside, So in addition to those factors, Liesel, you know, the regulation of practice around the country and around many places around the world has two components. One is that it is a regulation of the title, what we can call ourselves, psychologists. The other is a regulation of function, what it is that we actually do. And traditionally, the way one could practice across state lines without being licensed in another state, for example, has been either to do the whole process of getting licensed, which doesn't make any sense for a client who's going to be there for 3 weeks and then come back, or to use temporary practice rules in a variety of jurisdictions. But as you know, and if you'll forgive the bad pun, I'm full of them today, you know, states and countries are all over the map about temporary practice. So in California, if you are licensed in Alabama and you want to see a client who's now going to be visiting family for a couple of months in California, you can practice for up to 30 days in a calendar year without even notifying the licensing board. But if that same client were to visit friends or family in Michigan, you wouldn't be allowed temporary practice unless you're licensed in a state that has a physically adjacent land border to Michigan. So lots of variability here. And this variability has given rise to a need for interjurisdictional solutions, essentially. And for a variety of reasons, don't have time to go into today, a national license has not proven feasible. But as most of you are aware, SIPAC has, and it has developed remarkably in the past 10 years or so. It grew from 11 states in 2019 to, as of today, 42 states. So almost a fourfold increase. And SIPAC for member states and practitioners does bring a remarkable range of opportunities, and it lowers some barriers, especially as our clients or patients move around the country. They go to college or they get a job in a different place, or even, you know, when someone decides to move permanently because they want to. However, it's important to keep in mind that SIPAC is not simple. For example, if you hold an e-passport in your home state and you go to another state where you are not licensed, even if that state happens to be a SIPAC member state, you can't see any of your SIPAC patients who are outside of your home state. If you happen to be licensed in the other state, let's say you're licensed in Texas and Arizona, you would have to switch your home state. Not hard to do, but you'd have to switch it when you went to the other state in which you're licensed. You have to remember to do that. So most folks who are participants in SIPAC are not multi-state licensed. You are getting SIPAC for that very reason, so you can practice across state lines, okay? A second example of the complexity that SIPAC brings is that you have to comply in the receiving and distant state with all of the health and safety laws related to practice. So that includes involuntary treatment of someone, say, under the Baker Act in Florida, when you're someone in Washington State. So you have to know about the law there. And the SIPAC Commission has stated publicly as well that essentially one has to have the same level of knowledge and competence about state statutes and regulations and case law as a clinician fully licensed in that receiving or distant state. So one has to not only be knowledgeable about a very narrow band, but a relatively broad band of laws, child abuse reporting, record-keeping requirements, informed consent issues, just to name a few. And it's unlikely, in my view, that even the most competent psychologists can develop that kind of knowledge for 10 or 15 jurisdictions, never mind 42. So SIPAC has indeed lowered barriers, but it's important not to ignore the complexities. And one last thing before I turn it back over to you, Liesel, but by no means least, a number of clinicians across the country, when the need arises, have especially when clients or patients are traveling for a brief time, or the clinician, for ethical reasons, believes that there needs to be some continuity of care, even where it's not permitted under licensing laws or even under SIPAC, might continue, for example, for at least some sessions. A client, as one example, who happens to drive across state lines right in the middle of having a conversation with you briefly about the fact that they're feeling more suicidal, it would be devastating and very harmful and unethical just to drop the call. So I'll stop there for now.
Yes. Well, you also fit in a lot, and then you left us with a complex issue right at the end there. So I imagine, though, we might get a follow-up question or two on that we can come back and clarify. Eric, before we move on, anything you want to add to what Dan said?
Well, I just want to emphasize what Dan emphasized, which is I don't think just because PSYPACT allows you to practice in 42 jurisdictions, I don't think one should try and build a practice around multiple states or national practice, because learning the laws in each of the jurisdictions is complex, because not only are the laws sometimes, I mean, even lawyers can't sometimes figure out what the laws are in the states. So if you have to do 5 or 6 or 7 states, it's very difficult. And so what my advice to some people is, if you may want to consider, even if you are in PSYPACT, that there are only certain states in which you'll take clients. Even though you can take clients from 42 states, you may want to only say, okay, I'm only going to take states in the Midwest, or because I just don't have the capacity to have all the knowledge that's necessary to do more than a few states.
Yeah, no, I think that's a great point. And I think, I know we've talked, Dan, in some of the workshops we do also, that, if you're going to be practicing in many jurisdictions, probably also a really good idea to develop a network of colleagues in those jurisdictions who can provide backup care for you if and when you can't practice, right? Let's say you leave your home state and now you can't practice under PSYPACT, those kinds of things. Also, how do we, if we think about how we keep up to date on the law changes in our own states, right? We typically do that by having connections with colleagues, maybe being a member of the state psych association, so we get notices when there's a new law. If you're not linked into a state where you're practicing, you're not going to get those notices. And then you may not be, you may be violating laws that you don't know exist. So I think, yeah, really important. Lots of questions here to think through for clinicians. And so we'll come back to that. But before we do, I want to just, Eric, return to you real quick with the last subpoena question. Let's take a scenario again. Say that there's a 16-year-old, a clinician's been working with a 16-year-old, the parents are divorcing. The process of the divorce and custody battle is very stressful for this minor. And then in the middle of treatment, the father's attorney subpoenas the clinician both for the full record and to testify. And let's say, just to make it a little more complex, that in this state, the age of consent for mental health treatment is 16. And so what should the clinician do? There's a lot of things to think through, but can you speak a little bit about the complexities there?
Yes. Well, first of all, one of the reasons we put in the fact that the client was 16 and the age of consent is 16 gives the client the independent right to claim privilege. And so that would make it a much less complicated situation because essentially the psychologist in that situation could refuse to provide the information, and that refusal would be upheld because the consent would be with the client. The whole issue of consent is very important. One of the consent agreements we have at the trustinsurance.com is a model contract that one would have with parents around what happens if the parents are involved in a divorce or a custody case, and basically has both parents agree, in order to protect the child's privacy, that they will not in fact involve the therapist in the court at all. Now, in this case, that agreement is not a binding agreement, but it does make it less likely that this kind of situation would develop. But let's assume that we don't have that agreement with this father, or that the father decided, well, I did the agreement, but I'm still going to request the information. And one of the reasons that having that contract is really important is, since the judgment about what is going to be the decision about custody is going to be based on what's the best interest of the child. Somebody that agrees that they are going to protect the privacy of their children if they are in a divorce or a custody case, and then essentially decides not to honor that agreement, the other side is going to have a pretty good argument that they don't really care that much about their child, and that'll be an important fact in terms of, so the lawyers probably would advise the father not to request that information if he had signed that kind of a contract. The other thing is that let's assume that we don't have a contract here, though, and the patient isn't 16, she's 15. And you still, as a psychologist, want to protect the information. You can actually go into court and make a case that you shouldn't release the information because it will adversely affect the psychological well-being of the child. You can suggest to the other parent that they might want to get a guardian ad litem appointed for the child, who then can actually be approached as to what the child's best interest is. And there are increasing numbers of states now which require, in order to get the records of a child in a divorce case, that the court has some kind of process by which the parties have to go through in order to do that, where the child, even if they aren't of the age of consent, does have some protection for their records. Maryland, for example, requires that a child best interest lawyer be appointed if somebody's going to request that information. And so if there's a guardian ad litem or a child best interest lawyer, or even in a situation where you're not where you decide as a therapist that you want to go to court, you can and try to convince the court not to allow the records to be released. One of the things I usually recommend to people in that situation is it's very helpful to actually retain a lawyer to try to make that argument for you, trying to make it yourself as a therapist. As the old adage, someone who has themselves as a lawyer has a fool for a client. And so it's not a great idea, but I've got a number of calls about that. And psychologists, even though a lawyer is expensive, are often willing, and particularly in a situation where there's this kind of trauma for the child, to go into court with the assistance of a lawyer and ask that the judge protect the records. Also, in many states, you can ask the judge to have an in-camera hearing where the judge examines the records and decides what information is crucial to provide to the other side. But will protect the rest of the information from having to be released.
Very, very good points. Dan, anything to add?
Yeah, I just, with a minor who's now allowed to, by usually statutory rule, to consent to care, it's still important to be careful because it depends on the state and on the language itself. I know in my home state, it doesn't really say that the minor, if the parents bring the minor in, that they own privilege. It's a good argument, and I agree, Eric, with you that it's certainly reasonable to take that stance. But also, it's complicated because there's no case law, and there's just this ambiguous statute. So it's essentially a roundabout way of saying, Liesl, that I think, Eric, what you were saying, that having an agreement and being very clear about what you will and won't share is one way to help reduce that ambiguity and reduce the risk in the situation.
And Lisa, one other thing I wanted to say, that the thing we haven't really talked about is what happens in a SIPAC situation with these kinds of subpoena questions. Let's say you're in Texas, to use Dan's example, Texas, and you're working with someone in Maryland, and you get a subpoena from the Maryland court saying that you have to testify in a case where you're in Texas. Before SIPAC, it was very clear that that Maryland court would not have any jurisdiction over the psychologist and couldn't make them testify, and their subpoena would be invalid. They would have to actually get a court order and go to the state to actually enforce the subpoena. Now, you have to agree that when you participate in SIPAC, when you're working with someone in a different jurisdiction, that you'll follow their rules, but that doesn't necessarily mean that the court will extend jurisdiction. So that's an unanswered question about that makes an added complexity of interjurisdictional practice under SIPAC.
Yes, and I think both the additional points you made, thank you for them. Also, again, underscore, and I know I repeat this a lot, but this is complex and it's also case specific and state specific. So subpoenas in particular is also a very good place to consult because it's easy to step into something and make a misstep if you don't really understand all the different layers and levels. So consulting often there, I think, is a really good thing. All right.
Not to mention the fact that every psychologist I've ever talked to is terrified of the legal system altogether. The subpoena creates an enormous amount of fear and loathing.
Yeah.
Yes, a lot of anxiety. And as we know from behavioral economic science, we don't make the best decisions when we're anxious. So another good reason to consult. Okay, so let's go ahead and switch over to some of the live questions now. And the first one is, what are some of the ethical considerations when receiving a request for records for a client's life insurance application? So Dan, do you want to start on that one?
Sure. So it's primarily an issue of getting a release or having an authorization and confirming with the client or patient, Liesl, that they want this information disclosed. One of the ethical issues I see and pragmatic and clinical issues, whether they're past or current patient or client, is that it's really important to inform them about what's in the record. You know, we can't tell them do, apply, or don't, but often our clients or patients either don't know or don't recall what they've talked about in sessions. They may remember the good results they had, but not that they were talking a lot about suicide in the first 3 months of treatment. And that can have a profound impact on the life insurance policy application process. But ultimately, if we discuss that or review the record with the patient or client, and they say, no, I want you to send the record, and they put it in writing, then you would provide that because they have the right to decide where those records go.
Great. Eric, any addition there?
Well, I just would say that in a lot of situations involving courts, the question for the client is the money versus the privacy. Mm-hmm. And while therapy is considered to be a private activity, there are numbers of times when you actually have to choose between your privacy and your interest financially. And life insurance applications are one of those situations. If you say you can't release the records, there's a very good chance that you won't be able to get very much of a good life insurance policy or a disability, particularly a disability policy. So you should make it clear to the clients that that's the choice that they really have put themselves in. And you can advise them on both parts of it. But you can't resolve the issue. And oftentimes in cases, legal cases, when a patient is involved in a legal case, a personal injury case, for example, it's the same thing. By raising their mental status as part of their case, they give up their right to privilege and privacy. And it's kind of your money or your privacy.
Mm-hmm. Yeah, that's a great point. And, you know, one of the things I often hear in calls is the clinician will say, well, is there some way that I can discourage the patient from releasing these or something? And yes, I see both of you, we're all in agreement. No, you don't want to discourage or encourage. Our job as a psychologist is just to, as you say, Dan, inform them what's in the record. And then the client and their attorney need to decide whether they want to pull that into court or not. But that's not for us to determine or push in one direction or the other. So. Okay, next question. And Eric, I'll send this one to you to start. Since the recent federal lawsuit in Texas halting the implementation of the CTA BOI, which of course is the business ownership information statute, the reporting requirement, should we still make a BOI report, or should we wait until the case is resolved?
I'm going to ask whether Dan can answer this because I know that I can.
Yeah.
All right, great.
So there have now been a couple of appellate cases about the engaging and providing this information to the feds. And I don't think it's going to be terribly risky to wait, given that a federal court has weighed in and said no. It also isn't going to be terribly problematic if you go ahead and provide the information to the feds, because it's possible it could be overridden. There are two differing jurisdictions that I know of in terms of, at this point, their findings. So this may find its way up to the Supreme Court eventually. But it's hard to know what the result's going to be. I don't think there's much risk right now. This is basically the registration as a small business about, the idea of who has a beneficial interest in this organization. And it's intended at a federal level, for those of you who are not aware, to try to track possible terrorist organizations investing in American corporations or using them as shills. The likelihood of their doing that in my practice is it's probably even less likely than all three of us getting struck with a meteor right now at the same time. But never mind. So
Right.
yeah, I don't think there's a lot of risk to waiting.
Yeah, I agree. I think the risk is low. I think the only thing is you have to then keep up with whether or not what the outcome of the legal case is, right?
That's right.
If it doesn't get done away with, then you would have to potentially register at that point. So staying up to date. Great, thanks. All right, Eric, this one I'm tossing to you because you talked about subpoenas. And we've had a couple people ask, you mentioned in something you said there about quashing a subpoena, or the clinician moving to quash a subpoena. And so the question here is, what are some of the reasons why a clinician may want to do that, or may want to enlist an attorney to do that for them?
Well, the most important reason would be to try to protect in an instance where you want to protect the privacy of your client, particularly with children. It's important because they aren't independent agents and they can't make the kinds of decisions which we're talking about people making being involved in a court case and their privacy. Adults have made the decision to give up their privacy, or at least if their lawyer tells them. So that's some of the reasons to move to quash the subpoena. There are other reasons, such as the demand is too overly problematic in terms of burdensome. I'm sorry, that's the word I'm looking for. Overly burdensome. For example, if you basically have had a 6-year record of somebody and they want you to turn it in within 5 days, you can argue that that's unnecessarily burdensome. Sometimes you may argue that, and this again, you have to talk to your client about. If your client really wants to, redact some of the information from the subpoena because they believe that it's not relevant to the case that's involving the case, you may be able to quash subpoena on that basis. However, usually the best thing to do is, if the client wants to protect their privacy, let them and their attorney file the motion to quash.
Yeah, I agree. Dan, anything to add to that?
No, I think Eric nailed it.
All right, good. All right, so Dan, I'll toss this one to you. Can you discuss any reasons not to do Headway, Alma, etc.? I think those companies, the telehealth companies. They say here contracted rates for insurance are so low and often unchanging, and these companies do pay more. So maybe you can answer that and some of the complexities and or what clinicians should think about, because there are some issues, right?
Yeah, there are. So I'd be very careful about which company you select. I don't think they're in any means bad, or you shouldn't. But from a risk management perspective, you really have to read the small print, because, for example, will they let you take a client with you off the platform? How do you get in touch with the client directly? What if the client doesn't want to work with them anymore, but wants to work with you? And so there are a range of organizations out there. There are some that have no problem with that at all, but there are others you want to know before you get into a contract with them what the limits are going to be. So I think my primary suggestion and risk management advice here is read that small print that almost no one reads, but it's a contract you now have. The other issues are things like sometimes these organizations will submit billing, there'll be a deductible, and clients are not adequately informed about the fact that they're going to be paying privately or up to the point of their deductible. And as many of you know, deductibles can be $5,000. It could be $10,000. It could be a whole year's worth of therapy or close to it. And so looking at do they fund when there's a deductible? And most of the time, the answer to that question is no. They will not. They'll bill, and it'll be made clear that the person is paying down their deductible, but that client or patient has to pay. So the degree of good informed consent with the clients through these systems is another key component. Do they understand what they are getting into, just like we are trying by reading the small print to understand what we are getting into? Some of these companies have some real benefits. You're absolutely right. The rates are higher. They do the back office work very often. There have been some not so great experiences that some clinicians have had in years past, and not that long ago, 3-5 years ago, where some of the organizations have not complied with HIPAA very well, or they've ended therapeutic relationships where the clinician had no idea that it was going to end. So check reviews by colleagues, and especially, of course, we're risk managers, especially look at the negative experiences. It's one or two, not a big deal, but if you see a pattern of activity in a particular company, then your caution flags should go off.
Yeah, really, really great advice there. Eric, anything to add?
Well, it's an interesting business decision. One of the things I think therapists are psychologists are not often enough educated about are business issues. But every psychologist is a small business. And if you sign up with a bigger business in order to increase your revenue, you're signing up for all of the ways in which that operates. And sometimes it may not be worth the extra money. But sometimes it may be, for example, the example that Dan said, where you won't know that there's a big deductible. And by the time it gets back to you, you've already provided 3 or 4 sessions, which will essentially be free sessions. You have to decide the cost benefit of that possibility. But at least as far as Alma is concerned, most of the things I've heard people have been pretty satisfied with what they're getting from being part of it. I don't know about the other ones.
Yeah, I think I really want to underscore what both of you say, and also this idea that we need to know in advance. Really critical with these. Do your homework, read that contract. Another place I've seen some issues come up and had calls about is about records. So who's the custodian? Are they the custodian of the records? Are you the custodian of the records? Who is going to do the release of records? Will they release those records without you knowing they've released them? On and on. There's lots of questions for that. So really making sure you understand all the ins and outs ahead of time is really important before you sign that contract. So
can I say one more thing? Please
go for it.
There are all these systems where you have your records held by a third party business. My advice to people is always to keep a copy of your own record. So if something goes wrong with the company goes bankrupt, the company decides that they're not going to give you the record when you terminate the relationship. You always want to have a copy of your own records, even if it takes a little extra time and energy to create it.
Great advice.
Great. Yeah. Thank you for adding that. Okay, so Eric, I'm going to start with you. I don't think this is related to subpoenas per se, but it is about records. So what would you say to a clinician who's asking, can they provide a treatment summary if the patient agrees rather than providing the record?
You mean to a law in a legal situation, or?
Well, it doesn't say here, so let's first assume legal situation, and then I know it might vary.
So the point of it is, it depends on what it's for.
Yes.
If it's for a legal situation, if the therapist wants to have you send a subpoena, send a summary, most likely that's not going to be satisfied by the defense or the prosecution in a civil case. If you're sending a redacted record, you have to let people know that there's a redaction. You can't just send a summary and say, this is my record, because it's not your record, and that would be a violation of the subpoena. And my sense of it is, my advice to people in a legal case is never try to send a summary. Because when you send a summary or you say something is redacted, the lawyers on the other side it's going to be like their antennae are going to shoot up to
Right.
say, aha, they're trying to hide something from me. And now I'm going to have to get those records and look with a fine-tooth comb to try to figure out what they were trying to hide. And oftentimes what the client is interested in trying to hide isn't going to be all that relevant in their court case, but by not sending the records when you've been asked to send them, you're essentially tipping the other side off in a way that is going to adversarially affect you in a negative way. Mm-hmm. If you're in a court case, they're going to get the whole record. So there's no point in talking about a summary. Now, sometimes if the lawyer is representing you that wants that, the lawyer may not really need the whole record. They may be happy to take a summary just to help them figure out where the situation is. If it's the client's own lawyer and the lawyer is willing to take a summary, then there's no problem with that. But if I was the lawyer representing the psychologist in an actual civil suit, I would say, I want to see the whole record because I want to know what'll happen when the other side requests the whole record. And it's going to affect what our strategy is in the court case. And if I don't have that information, I can't really represent your interest as well as I should.
Mm-hmm. Yeah, great points. Dan, any additions there?
No, not on that one.
Okay. Yeah, the only thing sometimes I get questions related to this where there are clinicians who have policies that they will never release the full record, that they will only release a treatment summary. Right. And those are very risky. I mean, in this day and age, especially because even if it's just the patient who wants his or her or their own record, in most times they're going to be allowed to get the full record if in fact that's what they want.
In fact, it's illegal if it's actually a violation of HIPAA.
Yes.
And people have actually have been fined by HIPAA for not providing the whole record.
Yes.
Their argument is, well, I'm not doing it. I'm doing it not to protect you, but the law doesn't allow it.
Exactly. Especially if the patient's asking for it. So yeah, that was just a quick fitting that additional piece in there. Okay, so this is a question. They say, is anyone aware of a website where it has info regarding what each state requires in terms of the duty to warn? If not, how would I go about compiling this info so I have it for each state? Eric, sure.
Well, you can Google it. And there's a number of articles out there that basically, particularly for Terrozoff type issues, do go through all the 50 states. And you can also just call this trust.
Right.
Mm-hmm.
The other thing on that too, though, is it's hard to come up with very current. If you look online, most of the information you'll find goes back to the 2000s and even the 90s. And there are changes that have occurred over the years. So I think, Eric, those articles are a good place to start. And then coming to us or even going to the state itself and saying, what is the duty to protect in Texas or in Florida?
Well, I was trying not to get us overwhelmed, but the fact of the matter is the best thing always to do in a situation that most of the situation we've talked about is if you have any questions, call us.
Yeah.
Because we do have the expertise and we can, if there's some questions we can't answer, and you'll send you to a local lawyer, but you certainly can try.
Mm-hmm.
Yeah.
I'm sorry, Dan, go ahead.
No, go ahead.
I was just going to say an added resource, if you're a member of the State Psych Association, is to go to their ethics committee, the state ethics committee, who also oftentimes can connect you up with what the statutes are in each state. But to Eric's point, it depends. If you're trying then to interpret those statutes, that may be a different question, right? So again, consulting is a good idea. So, okay, Dan, I'll toss this one to you to start. And can you speak to some of the concerns and necessity/application of PsyPact that may be present for psychologists who practice coaching? And here, I think it's also about interjurisdictional, right?
Yeah, so interjurisdictional and PsyPact and coaching. So, remember that all of our licensing laws in the U.S., with some of them are different than others, but most of them are modeled after the APA model legislation. And so they're very broad. I only half jokingly say that if you're in your office and you sneeze, you're practicing psychology. Okay. And so if you're doing something that meets the duck test, as Eric has taught us all well about, which is, it looks like practice, it sounds like it swims like it quacks like it, bad pun intended, then boards will typically interpret your activity as such. So there typically is no limitation if you are, for example, somebody who has a passport and the necessary credentials. If you do coaching into all of the different states, you can do that. I mean, I think with the caveats that Eric was mentioning earlier and that you and I were talking about, Lisa, because coaching often is subsumed in terms of the activity that a psychologist can do. If you're not licensed in the other states, or you are not a member of SIPAC, or you're outside of your state, what we don't recommend is you just change it by calling what you're doing coaching, when in fact it is really just a continuation of psychotherapy, because calling it a different name doesn't help protect you. But if you're really doing coaching, very few states regulate coaching. In other words, our statutes for psychologists when we're licensed include that kind of activity often in their umbrella, but almost no states regulate coaching at all. So if you're truly doing, for example, executive coaching, is SIPAC necessary and relevant? Probably not. If you're a licensed psychologist, can it add a layer of safety for you? Because if somebody says, no, Dan, you were actually practicing psychology into Michigan, when in fact, you're calling yourself a coach, I can say, well, even if I was, I met the standards for being a coach, and I generally met the standards for psychologists as well. So I don't know if that directly answers the question, but I think that's what was being asked, Lisa.
Mm-hmm. Yep. Eric, anything to add?
In almost every case, coaching, which involves any kind of personal counseling, is the practice of psychology.
Yeah.
So calling something coaching, and remember, the board is going to look at it from their own perspective and from the perspective of the person who receives the services.
Mm-hmm.
So if you're coaching someone on how to have their better relationship with their spouse, that's going to be, and somebody then complains to the board, the spouse, for example, complains to the board, you can't say, oh, well, I was just coaching, because the licensing law is very clear that coaching is the practice of psychology. Anything that involves the educated use of behavioral interventions is the practice of psychology.
Mm-hmm. Mm-hmm. Okay, great. Thank you. So I'm going to fit in at least one more, maybe two, we'll see. But one question, and we get this a lot. Can you advise how to handle college student clients who are attending school in your home state, but returning home for school breaks in non-SIPAC states? Dan, you want to start with that?
Sure. Well, in some ways, it's very similar to what we were talking about before. If they're returning home and they're going to be there for quite a while, referring to a local provider is probably your safest bet. But if it's going to be brief, the student either has a high need for you, or they're relatively stable, you have a good relationship, a week or two at winter break is not likely to be very risky for you. But keep in mind that doesn't mean you're abiding by the law. And if it turns out that someone complains, kind of bouncing off of your example, Eric, if it's a parent who gets upset because this young person is becoming more independent and really using the therapist in a way to help them separate, the parent gets angry. If they complain, my desire to do continuity of care would not necessarily defend me if there was a board complaint in my home state. So you have to do a case by case, Lisa. Really, is this person suitable? Can I make it safe? Is there a possibility of temporary practice in this other state? If not, is it going to be brief? If it's going to go longer, again, we're not psychics. It's safer to refer if it's, the person's graduated, or they're going to be, in a different state for a semester or 2 semesters at a different university.
Mm-hmm. Right. And so Eric, I'll hand this one off to you. This is sort of the opposite. So instead of the client traveling, if I, the clinician, practice remotely and I travel, What are my risks in working with clients?
As long as you're working with a client in a state where you are licensed, except potentially in California, you are because of the transaction takes place where the client is. Technically, even if you're in Florida and you're licensed in Massachusetts and you're doing therapy with the Massachusetts clients, according to the way in which we have conceptualized cyber practice, you're actually in Massachusetts for purposes of regulation of that transaction. So yes, you can do it. However, if you're going to Florida, if you're in Florida and the person in Massachusetts lives in Massachusetts but's gone to New Hampshire for the summer, that you can't do, because that would be practicing in New Hampshire without a license. I do want to say one thing about the last thing, just in a point. Before all the SIPAC, there are some case laws that say in certain instances, practicing across state lines doesn't give the state where you're not licensed jurisdiction. And it's a very complicated situation. But if you have a complicated situation where you really feel like you need to practice with someone in a place that you're not licensed and you're not in SIPAC, you should call us, because there's a possibility we can create a rationale that will have some risk, but it is possible to think of a way of getting around some of those rules. And
Yeah.
Now we'll get a million calls.
I know. It's complex. It's not that every case will meet those standards for sure, but yes, call. And I just want to highlight too on the traveling clinician thing. I agree. Everything Eric said is of course correct. But the only caveat I want to add is if you are a SIPAC clinician and you travel outside of your home state, you could see your patient back in your home state, I suppose, in the state where you are licensed, but you cannot practice under SIPAC. So if you had other SIPAC patients in other states, you couldn't see them while you were away.